Lights, camera, action, that's it. Lights, camera, action, that's it.
Hello, I'm Professor Adekile, and I welcome you to the Faculty of Law, University of Lagos channel. In this series, we have our students in the studio who will be taking us through some interactions with the law. In the studio today, we have the Trailblazers. Yay! And they'll be leading our discussion on a case study that deals with the rule in Rylands and Fletcher. As you watch our presentation, don't forget to comment, like, share, and subscribe to the channel. Thank you very much. I'll hand over to Remy to introduce members of the Trailblazers.
Thank you, Prof. My name is Remilekun, and here with me are Olasukomi, Ayomide, and Samuel, our team lead.
Our discussion today concerns the rule in Rylands and Fletcher. So our case scenario is as those. One Amadioha, who constructed a fish pond capable of holding 10,000 liters of water, following a heavy downpour, the pond bursts, leading to the water escaping into his neighbor's compound, Mr. Ogun, and subsequently destroyed his vegetable gardens. Mr. Ogun is now suing Amadioha under the rule in Rylands and Fletcher. So it is important to note that the rule in Rylands and Fletcher is a strict liability tort. A tort is classified as a strict liability because it relieves the claimant the burden of proving fault of negligence. It is not absolute, as the law expressly recognizes some defenses as propounded by Blackburn J. in the Locus Classicus. The doctrine originates from the judgment of Blackburn J. in the Exchequer Chamber and reaffirmed by the judgment of Lord Kynes in the House of the Lords. And this particular rule is premised on three major principles or elements: touching upon non-natural use of land, escape of a dangerous thing, and resulting damage consequent upon the damage. Our discussion will examine each of these elements in relation to the facts present in the scenario. And we begin with the issues. So issue one would be on whether Mr. Amadioha definitely accumulated a dangerous substance on his land. On issue two, whether such accumulation constitutes a non-natural use of the land. Issue three, whether this a dangerous escape of substance from Amadioha's land, upholds the escape of the substance. Issue 4, we touch on whether the escape of dangerous substance caused foreseeable damage to the claimant, Mr. Ogun. And lastly, on the issue 5, whether the defendant, Mr. Amadioha, can successfully rely on the defense of act of God to evade liability. Now, we are going to begin with issue 1.
Thank you very much, Samuel. Now, I'll go to Ayomide. Samuel has told us that issue 1 relates to whether there was accumulation of dangerous things on the land. Would you like to speak to that?
Okay. I think that the first issue and the second issue are intertwined. That is the accumulation of a dangerous substance and the non-natural use of land. So over the years, many cases have been decided following the rule in Rylands and Fletcher. And, we have been able to say or summarize the elements required to prove prove liability in Rylands and Fletcher to 3. That's like the non-natural use of land, that it escaped, and that there was damage. So it is important for us to know what a non-natural use of land is. It is bringing something to the land, by the defendant, that the defendant brought something that was naturally not on the land. So in the case of Bartlett and Tottenham, yes, Lawrence J. held that it's something that was artificially brought to the land by the defendant. So in some cases, we can see that, a tree can be a natural use of land, and in some cases it can be a non-natural use of land. Okay. So thus, in the case of yes, thank you, Crownhurst and Amersham Burial Board, it was held that a poisonous tree that was planted by the defendant, which protruded into the claimant's land and his horse ate it and died, it was held to be a non-natural use of land, although it is a tree, which we might, consider to be natural. So, also in the case of
Nepal against Ali?
yes, Nepal and Ali,
Fire case.
the defendant's transformer blew, and it caught fire. It spread to the
Land of the claimant.
yes, to the land of the claimants. It was held to be a non-natural use of land, and so they were held liable. And I want us to also take note of the fact that although it says that the defendant must have brought it into the land, sometimes it might not even be the defendant that brought it into the land. It might be a third party, it might be an independent contractor. But if the defendant, has consent, if the defendant gives his consent, or he is,
His land.
yes, if he's aware of it, and maybe he does nothing about it. That's why in the definition, maybe I forgot to state that if it's a non-natural use of land is something that is there by the defendant's act or omission. So sometimes it might be his omission,
To remove it.
yes, to remove the thing from the land
actually.
that would make it a non-natural use of land. So applying this rule to this fact scenario at hand, we can say that the tank or the reservoir that Mr. Amadioha brought to the land is a non-natural use of land, because he artificially brought, the tank to the land. Normally, if the water was, naturally on the land, if it was there normally, it would not be held to be non-natural use of land. But this one was brought in by his acts. And so we can say that, yes, there was a non-natural use of land, and, it's likely to, cause damage if it escapes. So we can say there was an accumulation of a dangerous substance, which is a non-natural use of land in this case. Thank you.
Thank you very much, Ayomide. So she has spoken about the question of accumulation and non-natural use of land. And that's quite interesting. And you have laid the perspective that accumulation of water is non-natural use of land in this context. Moving forward, I would like you guys to do further research on the question whether non-natural use of land, changes with time. You understand? Whether it changes with time. What is non-natural user today may not be non-natural user tomorrow. So you might want to consider that perspective in doing your research further. Okay, so I would like to invite someone to talk about the question of escape. And I think that in that respect, Sukomi, would you like to take that?
Oh, yeah.
Okay.
The issue of escape, whether the tank and the water that was accumulated escaped to Mr. Zogun's land, I believe that it's a settled rule that the escape of the non-natural user that was brought onto the land is what creates a major distinction between the rule in Rylands and other similar torts, such that in Rylands there must have been an escape from the land of the defendant onto the person who is making a claim of damage. So a definition that talks about this basically is the one given by Lord Simmons in Reed and Lyons, where it said that there must have been an escape in regards to the rule in Rylands and Fletcher, is as regards moving the non-natural user moving from the land owned, occupied or controlled by the defendant onto one that it has no control or occupation, right? And that definition is actually very relevant when we check the facts of that Reed and Lyons. It was a case where there was a company that makes ammunitions. So there was an ammunition inspector officer who was to go and check it out. She got there and there was an explosion inside that particular building. Nothing went out. Nothing happened to those outside. But because she was inside that building, she got hurt. But she could not find any instance of negligence on their side. So she had to bring her case under Rylands. And the court was like, oh, listen, you were on the land when the explosion happened and there was no escape outside that particular building. So you cannot say that there was an escape such as to bring your claim under Rylands. And so as well as she could not bring her claim under negligence anyways. And yes, there are two interesting cases that I actually found very intriguing when I was reading this case, because it was the one of Poynton and Noakes and Krauss and Amersham Burial Board, because they happen to have the same facts, similar facts, right? But just that there was a minute difference, and that was what actually created the difference in the decision. In Poynton and Noakes, it was a case where a man planted huge trees, I guess, poisonous to animals. Then there was a slight protrusion to the land of the plaintiff and the defendant rather, and the horse ate it and died. In that case, because there was the minor escape of that tree branch to the land of the defendant, of the plaintiff rather, and the horse ate it, the court said there was a sufficient escape and they could bring their action under what's it called? That was the case of Krauss and Amersham Burial, but they could bring it. But in Poynton and Noakes, it was a case where there was also a tree, a non-natural user as well, but it did not protrude at all to the land of the plaintiff. It was the horse that actually stretched over to go and eat that thing. And the court said, listen, you can't bring your case under Krauss here. There was no escape. So that means it's just basic that for you to be able to succeed in an action under the Rylands and Fletcher, you must be able to prove that there was an escape. If not, I think I can tell you with my pleasure that you cannot succeed in your claim in that regard, right? So moving on, it's also good to know that it doesn't have to be what was brought into the land actually escaped. It could even be that thing causing something else to escape. Like in the case of Miles and Rock Forest Granite, where they actually brought explosives to the land. That was not a natural user. But the explosive caused granite to escape. And the court said that's enough escape. Because you can't say that, okay, what I brought didn't escape. It was something that was already in the land naturally that escaped. If what you brought to the land caused something already in the land to escape, same thing, my brother, you would be liable under the Rylands and Fletcher. Same thing in LMS International and Steinman packaging. Exactly. Because the same thing that, so long as that one was even a case of hot wire, what escaped was fire. But God said that's still sufficient for liability, and that was what God held you use them to hold them liable in those cases. So, in concluding, in application rather, I would say the accumulation of water in the tank brought to Mr. Amadioha, quite interesting in many ways, to the land is a non-natural user first, and also they said it escaped to the land of Mr. Ogun, and that's what I would say, that it is good to say that it would be good to suffice to conclude that prima facie Mr. Amadioha is liable. And I'm using the word prima facie because I'm trying to see there might be instances of defenses for him, but on the face of it, we can say he's liable in the Rylands and Fletcher.
Wow. Fantastic.
Thank you.
Yes, a very fantastic elucidation of the principle of escape under the rule in Rylands and Fletcher. So we'll go ahead and invite Remilekun to speak to the next issue that they have brought forward. Remilekun, over to you.
All right, thank you very much. My issue is on whether the escape of the dangerous substance caused foreseeable damage to the land of Mr. Ogun. Now, for the rule of Rylands and Fletcher to apply, there must have been an escape. That's the strict rule. That is a strict rule that the Rylands and Fletcher rule has been holding from time immemorial. But in the 1994 case of Cambridge Waterworks and Eastern Counties Leather, this case added a modern twist to the rule in Rylands and Fletcher. Before, to obtain a claim in Rylands and Fletcher, there just had to be an escape and damage must be caused. That's a very strict rule. But the case of Eastern Counties Leather and Cambridge Waterworks added a modern twist to the rule in Rylands and Fletcher. And this rule, this twist it added was the reasonable foreseeability test. It stated that the damage caused by the escape must have been reasonable foreseeable. So the case, reasonable foreseeability in this context means that if there is escape and there is damage, like the defendants must have reasonably foreseen that this thing that I'm accumulating is going to cause damage if it escapes. And that is why in the case of Cambridge Waterworks and Eastern Counties Leather, the court did not hold the defendants liable because the damage that was caused was not reasonable foreseeable, because that chemical that escaped, before it affected the claimants, it was not an illegal substance. Thank you.
The land was far away from where they were operating, and because it was like nobody would have thought that someone that is operating a tannery here would be able to like
Maybe 30 meters.
30 meters away. Like I'm doing something here in Akoka. You're telling me what I'm doing is affecting Akute, Ogun State. Are you joking with me? So the court was just trying to say that kind of a thing. Yeah.
All right. So, So, in application to the factual case, I believe that the harm done to Mr. Ogun by the escape of the water from Mr. Amadio's land was a reasonable, foreseeable harm.
Yeah. You can't come and put your land beside me and say you're not enjoying.
Interesting, Remilekun. Thank you for that perspective. Okay, so you concluded on the note of the harm done. So I would like someone to speak with respect to that, because you all know that the ruling Rylands and Fletcher, is not actionable per se. Yeah. And I noticed that in the case scenario, it was said that the plaintiff, the person complaining now, suffered damage. So would you like to speak to the question of the kind of injury that someone is permitted to claim for under the ruling Rylands and Fletcher?
Yes, thank you very much, Prof. So after the decision in Cambridge Waterworks, which established reasonable foreseeability, another monumental case came up, which is the Transco PLC and Stockport MBC case. Yeah. And this case, before this case, the courts were unsure whether Rylands and Fletcher would cover personal injury or death, claims of personal injury or death. Yeah. But in this case, the House of Lords affirmed that Rylands and Fletcher is only a subspecies of the tort of nuisance and only covers property damage. So it only covers the enjoyment and use of land. So it does not cover the harm caused to person or death. So I feel like in that case of Reed and Lyons, even if like the defendant got hurt on our own land from the escape of that fire, like bodily, I don't think she would have even succeeded under the rule in Rylands and Fletcher.
Yeah, because it was. You know, it's just so funny to see that some Nigerian courts are now applying it to personal injuries, but they are isolated cases. Because the rule still stands that it should be for a landed property, right, and not for personal injuries, right?
That's why Professor Chimba put for.
Yeah, she was conceptualizing Nigeria's approach to the union.
And it's very important we underscore the judgment made by Blackburn J, you know, and also Lord Kynes, because they both lordships made different rules, thereby distinguishing a wider rule and the narrow rule, saying that yes, it's a wider rule when it's been applicable to personal injuries, which Lord Kynes, you know, accurately refused to follow that kind of pathway led by Blackburn J by saying that it must always be with respect to damage to, you know, to property, because when it's a damage to personal injury, it then confuses, you know, other areas of tort, just like a nuisance and of course the case of negligence.
Yes.
Okay, thank you very much, Samuel. Actually, that introduces the understanding that the interactions flow between Rylands and Fletcher, the tort of nuisance, and even negligence. And from what you guys have said, you know, the reasonable foreseeability is as much a part of Rylands and Fletcher as it is of the tort of negligence and the tort of nuisance, and that there could be jurisdictional perspectives to some of these things. Thank you very much. And I will invite Samuel to continue with this discussion by discussing the next issue that we want to talk about, which is the available defenses that could be pursued in this case scenario.
Yeah, thank you, Prof. I'll be taking the last issue, which borders on the available defenses upon which Mr. Amadioha can validly rely on to evade liability. So it is important to know that, like I reiterated earlier, that the rule in Rylands and Fletcher is not an absolute rule. Instead, it is just a strict rule. So although the original case, which is the case of Rylands, and Fletcher did not expressly state, you know, these available defenses, but with the track of time they developed as the court started reasoning, you know, how this rule definitely will not do injustice. So as a time evolved, later decisions, you know, laid foundations for certain defenses that will be available upon a defendant whose dangerous substance escaped and caused damage to a given plaintiff, and among them the defenses of an act of God, voluntary non-fit injuria, contributing negligence, and of course statutory authority. But for the purpose of our case scenario, we are going to dwell majorly on the defense of act of God. So the act of God defense applies where the escape costs, is as a result of pure and natural consequences, only a natural phenomenon such as maybe thunderstorm or heavy rain. And as we actually see in the instant case, that as a result of a heavy downpour upon the property of Mr. Amadioha, then the fish pond actually burst and caused a given damage. And to illustrate this fact, the case of Nichols and Marsland, in that case is an exceptional case because a thunderstorm, described by the witnesses as a special one of its kind in the history of humanity, say that the thunderstorm, hits the given artificially constructed by the defendant. So the court in construing this was able to lay a clear distinction that when the act which purported the given escape isn't as a result of the fault or the negligence of maybe the defendant. Now the defendant can rely on this to say that I can evade the liability. And this is in contrast with the case of Greenlock Corporation and Caledonian Railway Corporation. In that case, it's a similar fact. But for the fact that the defendant carried out some construction work to paddle the swimming pool, and when the thunderstorm or maybe heavy rain, caused or occasioned an escape in that particular circumstance, the court held that for the fact that the defendant had, certain kind of control over that body of water, they were held liable. So in applying in this case in the instant scenario, we can say that Amadioha, though he constructed a fish pond that contained or hold 10,000 liters of water, he took reasonable care to make sure that there was no negligence on his part. But this irrefutable, intervention by an act of God, that is the danger, the thunderstorm, we can see that he cannot be held liable based on this authority. So in advising Amadioha, he should, validly approach the court and invoke this defense and then, walk away from the liability under the ruling of Fletcher.
Yes. Thank you.
That's a nice one.
That's
Yeah.
very nice.
Yes, give it up for Trailblazers. Give up for Trailblazers. Yes. Yes, a fantastic intersection. So, we've talked about this case scenario and the rule in Rylands and Fletcher. And what would you would see from this perspective from the Trailblazers is the fact that in a typical exam situation, when you have your facts, don't forget your law. See the law before you apply. And you can see that they took time to explain the law before they applied the facts. Okay, give it up for Trailblazers. Give it to them. Yes, they're really blazing the trail. Okay, so we look forward to have you back on the channel some other time. So our audience, I say thank you very much for keeping in touch. We remind you to remember to comment on the video, to like the video, to share and subscribe for more interesting educational materials.
Thank you.
Thank you very much.
Thank you, Ma. Thank you for having us.
Lights, camera, action.